Michelle Graves, your host on The Power of Money, and I'm honored to have you as a part of my world in this coming segment. With The Power of Money, as you know, we are interested in three things. First, that you get the necessary education so that you and your family will have the information to do well in these difficult times. The second thing I'm interested in is for you to be empowered to prosper. I want only the best for you, but you can't get that if you don't have the education and then the drive to make it happen. And the final thing, and perhaps the most important thing, is that you be energized. Because life is more than a journey. Life is about living. And so I want you to learn these things and to be empowered and encouraged and energized. I'm Michelle Graves. Now here we go. I'm your host, Michelle Graves, and welcome to today's segment of The Power of Money. And as always, I'm delighted to be in your world, and thank you for being in mine. We have an extraordinary guest on set today, and so just sit down and get a pen and pencil if you wish. But my guest today for the next hour is the Honorable Judge Cheryl D. Grant from Hamilton County Courts of Cincinnati, Ohio, an African-American woman who has sat on the bench for over 20 years and has just recently retired. And I am just honored to have her here, first because Judge Grant was a trailblazer and in my estimation remains a trailblazer for the rights of people and for fairness and justice. And so she comes out of a background as a police officer where she was a first, and then into judgeship in a very, very tough county, and where she successfully ran and was reelected and reelected. So the people recognized her integrity and her fairness. So I'm just honored to be one of the few people that's known her forever. Forever. She was my attorney when I was struggling in business. And she was always incredibly fair with me and handled my circumstances properly. And I just loved her and remained one of her loyal, devoted friends. So don't you say anything funny because you're going to get a backslap for real. So anyway, honored to have you here today.
Thank you, Michelle.
Where do we want to begin with Honorable Judge Cheryl D. Grant? What's a good place to start?
Well, I think a good place to start would be how I came to be part of the Hamilton County Municipal Court system. I was first elected in 1997.
That's amazing.
But I ran and lost before then. I ran and lost, and then I came back in 97 and I won. But I filled an unexpired seat, so I had to run again in 2000 to get my full term. Hamilton County is different than all of the other counties in the state of Ohio for election of Hamilton County Municipal Court judges or municipal court judges. First of all, we have a combined court.
I didn't know that.
Our jurisdiction is all of Hamilton County. A good reference is Cleveland. Cleveland has a city court, and then they have the county courts in Cuyahoga County. They have separate systems.
Okay.
Butler County has separate systems. Hamilton County has a combined court. And that's not unusual because there's one in Franklin and other bigger counties. But what's unusual about Hamilton County is because of a lawsuit that alleged that minority attorneys could not be elected judge because of the racism in the county. Therefore, as a result of that, there was a consent decree, or, well, maybe that's legally not a consent decree, but there was an agreement that the county would be divided up into 7 districts for voting purposes only and for municipal court judges only. So we have 2 judges that sit in each district. I ran first in District 3, but I've been sitting in District 2 voting areas since 1997.
Okay.
So we have 14 judges, 2 in each district.
Okay.
And on the current court, we have a Democratic minority judges sitting in District 1, 2, and 3. So there's six of us
Okay.
sitting in those judgeships.
Now, is
So
that
that
how
was
it's-
unique for Hamilton County.
I think that's unique today.
Oh, it is. There are 88 counties in Ohio, and Hamilton County is the only county that elects municipal court judges by district.
My goodness. So generally speaking, judges are elected for the entire county.
Yeah, the jurisdiction
Yeah.
entails the entire county,
Okay.
but the voting, that's why I want to make it clear, the voting district, the people who elect us live in a certain area. For instance, District 2 covers Bond Hill, some parts of Roselawn, North Avondale, some parts of North Avondale, some parts of Westwood, some parts of College Hill. It's a drawn district.
Okay.
And so there's 7 of those, and that's what so you vote, for instance, you were living in my district because you once lived in Kennedy Heights.
Exactly.
So you would vote for me. Kennedy Heights is in District 2. You would vote for me. Now, Silverton is not. That was in District 3.
Okay.
But Kennedy Heights is. So you would vote for me, but my jurisdiction, cases that I handle, were for the entire Hamilton County.
That is so odd.
Well,
That is
that's
very odd.
Yeah, we were able to get minority judges elected under that system.
And has it worked well?
It's worked well. As today, though, we've had some minority judges who are elected county-wise for the Court of Common Pleas.
Okay.
And retired Judge Nadine Allen,
yeah.
she ran in the county and won. And was
Okay.
successful in winning in the county, which was unique at that time because it was very, very difficult. And I think Judge Melva Marsh, who currently sits on the Common Pleas Court, but I
Okay.
sit in the chair that she sat in on municipal court.
Okay.
And I think Melva came late, I call him, Judge Marsh came later, and she also won a county race. So we've had some judges who were able and successful in overcoming that bridge there, but it was very difficult.
I can imagine. I must be open, and that is Hamilton County does not have a good reputation. Historically, with regard to African American representation in the court system, in the police system, in the legal, it just does not have a good reputation. Now, I cannot speak today, but I do know that coming up, it was not perceived as a friendly environment.
Absolutely, absolutely. And you and I both came up in the county and in the city.
Yes, we did.
So we know the history, and the history is not good. And when you think of being inclusive for different political thought and different racism and sexism was alive and well in Hamilton
Very much
County.
alive and well, very much alive and well. During your tenure over the 20 years that you sat in that seat, have you seen change?
Oh, it's up and down. Things that are, sometimes things happen that you say, wow, I thought we were past that.
Right.
And then we'll go back and then we will come forward and then we will go back. When I came on the court, it was the majority of the judges were Republican because it's a Republican county. And when I came on the court, I was one of the few Democrats, and that's significant in the county, even though we're nonpartisan in voting and anything. It's really significant about the party structure.
Yes.
But we had I would assess it as a good court because even though we were all over the spectrum in our political thought and how we thought things should be, we sat at the table and we talked. And we were able
Really?
to we were able to put forth a different perspective to the judges, and the judges were open to that. So, for instance, when I sat on the bench, I was in what we call when you're a duty judge. At that point in time, you were duty judge, and they would call you Room B or Room A duty judge. We had a DUI docket or a license docket. When I first started, I went to the room for this docket, and everyone who had driving without a license and et cetera. And I was appalled and very disturbed by the fact that under the law, you could get your car immobilized and impounded if you were arrested for driving without a license, not convicted, but arrested.
But just arrested.
And I would sit in that room and people would cry. You know, there's transportation is poor, public transportation is poor in our county, and a lot of the jobs were in the county, so people would come in and cry and say, I won't have a job, I can't get to my job, they have impounded my car, immobilized my car, and I just can't get to work. And I mean, and someone else would drive your car and you would have your car impounded even though that person was not the owner of that car. Well, we developed what we call the License Intervention Program.
Oh my goodness.
It has been adopted by other counties in the state, but what we did, we allowed people to keep their cars and until such time that they were convicted, and then we had to, of course, comply with the law, but we helped people in this program get their license. So that to me was a shining example of how you could work together and be positive and make something positive happen. So I've always been, that's one of the highlights of us sitting on the bench is having the License Intervention Program. Because people don't realize how many ways you can get your license suspended in Ohio and never drive. So because you know, I don't.
But I'd like to know. I mean, it's more than just drunk driving.
Yeah, because the legislature felt that if you did another crime like drugs, we should take your license away, which it may have absolutely nothing to do with the criminal offense. And so what you did was people will say, Judge, I know I shouldn't drive because I don't have a license, but I have to drive.
But I have to drive.
I have to drive. I have to support my family. I have to pay my rent. And then the fees from the Bureau was just over the top. One day I had the experience with a nephew of going out to the Bureau and helping him get his license back.
Okay.
When I got through that experience, I said, anyone who tells me they went to the Bureau of Motor Vehicles to get their license back, I am going to look at their case differently. Because it was a trial. I mean, it was it was really, really a difficult procedure, a long involved procedure, and I just was amazed.
For them to get their license back.
Returned, yes, after being suspended. It was opening for me, and I looked at this system altogether different at that one experience of going to the Bureau. But we also, in putting the stress on the Bureau, the law has changed in a lot of ways. For instance, now the Bureau will allow you to go to your clerk of court and get on the docket, and then like in Hamilton County Municipal Court and in all municipal courts, you can go and get driving privileges now if you enter into an agreement with the Bureau to pay your fees.
So you can do an installment plan?
Installment plan.
That makes perfectly good sense.
And that, to me, that was the best rule that came out of the Bureau of Motor Vehicles was the installment plan. When you live in a county as large as Hamilton County, when you have many of your non-professional jobs in the county, transportation is very, very important.
Yes.
And when you have no car, I don't know how people do it, but with the people with automobiles and don't have license, then it just becomes very, very difficult to support yourself. So that has a lot to do with the lack of transportation in our county.
Okay.
And the other has to do with, not to have your license suspended for other than non-driving. But of course, I'm not the legislature. We have to comply with the law. But that was one of the shining moments of sitting on the bench for me, because we saw a problem.
And then work together.
And we worked together to create a solution that worked pretty well, because we got a lot of people licensed. We enable a lot of people to get licensed. And then people did not know. You go to Florida and you're driving down the highway, and they've got the airplanes, used as a speed detector. You don't know about it. You get home, you get stopped by any officer in the county, and they say your license is suspended, and you're saying, what? My license is not suspended. And then they say, well, you need to call the bureau, and the bureau say, well, you were in Florida on such and such a day,
and
you got a ticket, and you didn't pay your ticket, and your license is suspended until you take care of it.
Well, how would you know, in the case that you've just given, if a person is cited in Florida by a plane, do they send a notification to their resident?
I don't know if they do that.
How do you know you're even under the radar?
Most people will say, I did not know. So I don't know what the rules and the statute is in Florida, but I know most people would come and say, Judge, I did not know my license was suspended. And but the Bureau of Motor Vehicles of Ohio know your license is suspended. So whatever notification comes forth, your license suspension will come to the Bureau. But in cases like that, we're saying, okay, let's give people an opportunity
to get this right.
To get this straight with Florida. And I'm just using Florida as an example, because it's not the only state that use air speed detection. Because
you're giving me new information. My son lives in Florida. I guess I won't be driving in Florida. I'll be renting a car.
You need to comply with the speeding laws, wherever they are. Because they're all different also. But yes, that was we had speed detection by air in Ohio too, and I sat in my first trial, and it was very interesting to me, because I was wondering how it could be measured from the air. So I learned all there was to know.
And it can be measured from the air.
And it's
accurately.
Well, they have. It's been approved. We will say, if that speed detection device has met the standards approved, then we have to comply with it. Some people, of course, challenge it, and we listen to the challenges.
But the documentation.
Well, the documentation is there, but if you challenge a speed detection device, you need to challenge the device. And there's a limit to how far you can go, but if you come in and say, we've had people come in and say, Judge, I was not speeding, and then they'll present their case and they'll never tell you what their speed was. And so at the end, I would say, but I don't know how fast you were driving. And the officer with the radar or with the laser device said that you were going at this level, and you didn't tell me how fast or how slow, whatever. I said, so the only speed I have in record here is what the officer has reported. So that's the biggest challenges on pro se, on speeding. But a lot of people who challenge the speeding don't take time to learn all there is to know about the speed detective device.
Can I ask a question, Nate? Is it, when you said pro se, and for those of you listening, and pro se means you represent yourself. The court allows you to represent yourself. Do you think that's wise?
I don't encourage it. I think that people get very emotional. They said lawyers shouldn't represent yourself. If I had a legal issue, I hired me a lawyer.
I would think
even though I was a lawyer, because you get very emotional and you don't hear what's being said. And especially if you feel that you've been wronged. I mean, you can't hear anything, and so emotions get in the way. I've had to tell people in court, let's take take a breath, just breathe, just
Okay.
stop, just listen. And then and some people get so angry because you have to follow the rules of evidence, the rules of procedure, the rules on how to govern the court. And they get so angry, they'll say, I don't want to go forward with this, I'm stopping. Or they'll get on and you tell them, do you have an opening statement? But remember, it's not evidence. So whatever you tell me, it's not evidence. Evidence is when I swear you in,
Yes.
and you sit in that witness chair, and you proceed to testify. That's evidence if it's admitted, if it's not objected. They don't hear that. So they'll give me this long summary of why they're not guilty,
Okay.
and then they'll become their own witness, or they'll say, I don't want to be a witness. And I'm saying, you don't have your story in. But I said, are you sure? No, I don't want to testify. You don't have to testify. I said, the Constitution protects you from testifying. I said, but I can only consider what I've heard. Mm-hmm. And if you don't testify, I just want you to remember I can only consider what I've heard and what has been admitted into evidence. I don't tell them because you can decide not to testify under the Constitution, and it cannot be used against you.
Really?
But
Okay.
There's certain times, especially in these pro se trials, when it's me and we're the only witnesses there.
Okay.
And sometimes you need to know what happened from your perspective, because in your opening statement, you told me you had a defense. And then when you're ready for your side, when I said, do you have a witness? No, I don't have a witness. I said, well you can call yourself as a witness. No, I don't want to call myself as a witness. So, being a pro se, even plaintiff in the civil matter, it's an issue. Defendant in criminal matter is an issue. I just say for people, and there are reasons why. A lot of people in traffic, you don't get assigned in minor misdemeanor traffic. You're not entitled to an assignment of an attorney.
Okay, so you have to pay an attorney.
You have to pay. And if your fine is going to be $20 in costs, in Hamilton County is $130, or if it's going to be $5 in costs, or it's going to be just costs, well, you may have to pay $500 to get just cost, or a fining cost. And so people will often say, I can't afford to get an attorney. And I would just tell them, well, if you have a complicated matter, then at least get advice of counsel. Go to the library and just skim the rules, but at least get advice.
Well, I just think it's kind of like self-medicating versus a doctor. And that is that if you enter into an arena that you know very little about, just wisdom says, take advantage of what is in front of you and work it out. If you've come into a problem with the law, then you retain counsel. I mean, I'm just matter of fact about that, because you all are the ones, when you're talking about the Constitution, and I mean, this is why Washington is in such a mess, because the American people, we don't know what that means. How does that translate into the legalities of it all?
But if you make that decision, because we have some people who are freemen, we have some people who are sovereign, they don't accept jurisdiction by the
I keep hearing that. Is that real?
Very real.
That is seriously real?
Very real.
Judge Grant, I'm serious. When you hear people say, I don't have to go because I'm sovereign, that is real?
It is real. And there are a number of people who...
I thought that was just bogus.
Oh, there's a number of people who prescribe to that political thought, and they come to court. The only problem that just because you say we don't have jurisdiction doesn't mean we don't have jurisdiction.
Well, I'm going to say you have a police force.
So if you are charged and you come to court and you say that you have no jurisdiction over me, I don't accept the jurisdiction of this court, I'm sovereign, etc., I will say that's fine. But you are charged with, let's say, theft. You're charged with this theft charge, and that this is what the law says. And this is what you're standing before me. And I will say you have a right to have counsel, and I'll go through the whole thing, and they'll say, I don't want counsel because I'm not accepting jurisdiction of the court. I say, well, have a seat because we're going to have a trial.
Oh, no.
So we go ahead with the trial, and they will not participate, and they will be found guilty. And I just advise them, if the state is able to prove their case beyond a reasonable doubt. You don't, if you stand mute at the table and say nothing, it doesn't change the burden of the prosecutor. The burden of proof. The prosecutor in criminal matters must prove you guilty beyond a reasonable doubt. So whatever evidence that comes forth, whoever is prosecuting must present evidence to find you guilty. So you can sit at the table and say nothing, participate, put your head up in the air, and I may find you not guilty because the state did not meet its burden.
Okay.
The burden doesn't change because you say you're sovereign or you're a freeman, or in some cases you're an Israelite and you're this and you're that. That doesn't change. So you can be moot if you want, but the state still has the same burden. Whoever is prosecuting.
Whoever is, so the whole concept of sovereignty and I'm a free person does not have merit in a court environment.
No. But they will say, I mean,
I'm
we
so
get that all the
serious.
time.
I did not know this was
Yes.
legitimate.
Yes.
Judge Grant,
Yeah.
I'm not kidding. I didn't know this was legitimate. I
And,
just thought
and
they
yeah,
were just
and
crazy
when we
people.
get through, we will tell them, I've told them that, you know, you have a right to appeal my decision, and you have 30 days in order to appeal my decision. I would just suggest, if you decide to go to the Court of Appeals, that you at least
Don't
talk
tell
to
them you're
counsel.
sorry.
But they won't, and they'll go to Court of Appeals and they'll lose because they're still under the jurisdiction of the United States. Whether they consider themselves non-citizens is beside the point. You can be a non-citizen and still be charged and held accountable. So it becomes quite a challenge to a judge when you have a person, because you really want them to understand that, notwithstanding your profession here of being a sovereign or being a freeman or being whatever you are declaring, I still have jurisdiction over you, and the case must proceed. And sometimes people will go out. I had one person who represented himself and he won. I mean, I found him not guilty.
Really?
Yeah.
Okay.
And then I've had others who will either sit there and not say anything, or they'll not know what to do. And if it's really very serious, I may ask, a public defender will say to me, Judge, this person says that he or she does not want me to represent in this proceedings, and I will say, I'm not withdrawing you. You sit at the table, and as this trial proceeds, I will allow this person to be pro se, but you are at the table and you need to be on guard and look out for their rights. We try very hard.
That gives me such a different perspective about what you're doing on that bench.
Well, I can tell you,
God.
we have the vexatious defendants. They will file a lawsuit on anything, and they always file against the judge. And so, you know, when I was on the bench, I'm thinking, you know, this person has been filing, suing all the judges. And it was over at that time an expungement of the record.
Okay.
And he had a charge in Kentucky. And when I looked at the charge, I said, now the state of Kentucky probably treats this charge differently than the state of Ohio.
Okay.
I said, so let me look at the law in Kentucky to see whether or not this case can be expunged in Kentucky or how it is treated in Kentucky, because if it's treated as a minor misdemeanor, akin to what our minor misdemeanor is, I can go ahead and expunge this man's record,
In
and
Ohio.
maybe he will stop suing everybody.
Yes.
I looked at the law, I read it, and I inquired about how this law was treated in Kentucky, and I made a decision that this law was treated as a minor misdemeanor. So I expunged his record. He sued me anyway. So
What was the basis of
I
the
violated
suit?
his civil rights.
You violated his civil rights?
Yeah, along with a couple of other judges. Even though I don't even think he understood that he won. But
Was he pro se?
yes, of
Oh,
course.
because I was like, what normal
And
attorney?
then they'll file suit in the Hamilton County Court when it reads a federal system. It reads a federal, in the federal court of the Southern District of Ohio, and then they come over in Hamilton County and file it. But, I said,
Now, it would have no standing.
No, they don't.
In Hamilton County.
No, and I inquired with the clerk, why do you accept the paperwork?
Yeah.
Well, we have to accept everything that comes through. This is some formal clerks, but I say they don't do that in the federal system. I said the clerk will not allow you to file papers that they don't have jurisdiction over. You're not making a decision, but you know the jurisdiction of the court.
Right.
But I lost that battle.
Oh my God.
But the bottom line, I learned the lesson early. If this is what makes your life happy, that you can go sue everybody and you can go sue
Pay
the
fees,
judges.
filing fees, defend.
Oh, no.
What?
No, they don't pay filing fees.
You do
They
not
ask for the
pay.
court, they ask for the court to waive the fees because they're indigent.
Oh, this is good.
So, but anyway, it's those are the highlights of sitting on the bench, which I'll never forget.
No, I have to go back here. How do you claim indigency, meaning you don't have the financial means to pay the fees, but you're going to sue is there financial compensation if they win?
Well, it can be, but
they're indigent.
They're indigent.
Okay, all right.
But
Excuse me, viewers, indigents are broke people. Just point of clarity, because she's an attorney, judge. I'm just a regular person. And indigent means you have no money. Thank you.
You have no money to pay for the filing fee.
Exactly.
Now, that does not necessarily mean that you have $0. It's just that there's an affidavit you have to
that you
fill
have
out,
no money.
and the court has to make a determination that you are indigent. But what happens to vexatious litigators is that if the court declares that person a vexatious litigator, meaning they file lawsuit after lawsuit after lawsuit, then the court can say that before we allow you to file a lawsuit, it has to be reviewed, and before we allow you to provide you indigency status, everything has to be reviewed. Now, they won't deny, it's like calling a fire in the room when there's no fire, but when there's actually a fire, nobody believes you.
Right.
Well, they don't actually deny this person. First of all, some court has to rule that that person is a vexatious litigator.
Okay.
So the court will still allow you, if something should happen and you need your rights protected, but you can't file it without it being reviewed. So we have
now, who does the review? The council of judges?
Court generally, whoever's assigned, or the clerk will generally, in the federal court, I think it happens at the clerk's level.
Okay.
But I believe it happens at the clerk's level. But in our court, it would probably come to a duty judge to look at it to see whether or not there's any, based on the allegations itself, if you can read them, because usually it's very difficult to understand. Now, I learned a long time ago that there's a limit to how much understanding I can give to a paper. And so if somebody writes me something that makes absolutely no sense, now, they may not follow somebody may submit a letter when they're supposed to submit a complaint.
Okay.
And the letter does not meet any of the rules as a complaint.
Right.
But if they tell me in the letter that, somebody, for example, I was walking down the street and I slipped and I fell and blah, blah, this, that, and the other, even if it's in letter form, I can treat it as a complaint if I desire to do that, but not. We do a lot of that in Hamilton County, but in some jurisdictions,
they will not
accept that you have to follow the form. But if I get a letter and I can't understand it, I don't know what you're telling me, I can't read it, it's illiterate, it doesn't make sense,
Right.
or it's a bunch of statements that you put together, then I will tell people that I'm dismissing this complaint, but I may say I'll give you 30 days or 28 days or 10 days or 15 days to file an amended complaint
Okay.
establishing what your grounds are for the lawsuit. And if you fail to do that, I'm going to dismiss. I no longer try to, some things I just couldn't understand. I mean, it was just, and I said, there's a limit to how far we can go here.
Right.
And if you can't understand it as a judge, the person who has the responsibility of answering the complaint,
yeah.
will not understand. So I decided that I could not let go complaints that made no reasonable sense. Now, on a lot of the other complaints of sovereign people, they would take federal language and just take it out of cases and out of the rule book or out of a reporting and just put that language on paper and just string sentences together. And
cut and paste.
Yeah.
Yeah,
and then so I would read it, and if I could make some heads or tails out of it or make some headway with it, I'll let it go through. But if it's just stringing along sentences, then and it doesn't make sense to me, then I have to not allow that complaint to go forward. So that's one of the things that I was not expecting when I sat on the bench. So because as an attorney, I didn't have to deal with that day to day. So I've been in the practice of law, what, 45 years?
Yeah, that's about 45 years.
So but I've done a lot of things over the 45 years, but those are some of the highlights of being a municipal court judge that many people don't understand, that you want to give people the benefit of the doubt, and you want to help people to set forth their claim even if they're not doing it right. And so what I do is that I will send a letter out when I get a complaint and say, you're doing this pro se, but enclosed is a form that has all of the public attorney offices, not the public defender, because generally this is in civil cases.
Okay.
Because in our county, the public defender meets you at the jail. I mean, if you want a public defender, you can get a public defender immediately. But in civil matters, there are a list of agencies that will represent.
Oh, really?
So, not only the legal aid, but we have lawyers, volunteer lawyers for the poor.
Okay.
And then you have lawyers for senior citizens.
Right, pro-seniors,
under pro-seniors. So I will give people a list and tell them, call these offices to see if you could get representation.
Do you find, and I guess I don't want to sound offensive, but one of the things that I have observed over more recently, the last 5+ years, is what I call a callous disregard of the court protocol.
Oh, yeah.
Can you speak on that? Because
that's been difficult for me because I came up in the old school. And
me too.
And there's certain things that you did not say in the court, especially to a judge. That's changed. There's a whole different attitude out there. Now, I've been cursed out.
In court?
In court, and I've been cursed out in court. I've held some people in contempt of court for being abusive toward me and others. And then what I generally tell a person, if you don't like what I say, that's all well and good. I can't change that. But if you want to say something about it or bring voice to it, you need to do that outside of my courtroom. You go out in front of the county building or outside my courtroom. You can call me any name you want to, but I can't allow you to disrupt the court. I can't allow you to have your contemptuous behavior before the court. I have other people in the court. You set the example. And so if you are going to I call them callous and disrespectful and defaming before the court, then I can't allow that. I said, because see, I represent the court, but there is a court here. It is a separate system. I had a lady that I had to lock up. She was there as a witness.
Okay.
In a domestic violence matter.
Okay.
And her boyfriend, I think it was a boyfriend, after his trial, and he pled, I think he pled guilty or no contest.
Okay.
And I found him guilty. He had been in jail, and I said, okay, let me set up some treatment and do some other things. And he had to go back to the jail. She was in the back of the courtroom, and I mean, she performed.
In the court?
Yeah, but she was upset because I locked him up a few more days. She wasn't upset because of the sentence that I was allowing him to get treatment and leave the court,
Right,
etc.
right.
I mean, that girl called me everything she could, and I mean, she just went off. And I finally said to her,
what is
you
wrong?
came here as a witness, and the defendant is going to leave the jail in a couple of days, and you're going to be there for the next 180 days. So
that's really, that's not funny.
I locked her up.
Yeah.
Because I mean, she just lost it, and generally what I say to a person, I tell the court reporter, note the time. I tell the person, stop. If you continue, I'm going to have to hold you in contempt because you're holding up the court, you're being disrespectful, you're cursing, you're just doing things that I can't allow you to do. Then I will go to this. If I tell you one more time to stop, I'm going to give you 10 days. If I tell you one more time, she was up to 180 days and still wasn't stopping.
Still wasn't stopping.
So she went to jail, and she stayed there 90 days before she came back to ask me. Now, what they didn't know is that when I put them in jail, all they had to do was say, Judge, I'm sorry, it won't happen again.
Right.
And I generally let them back out. But she sat there 90 days before she finally filed a motion to come before me in order to get her sentence reduced. She was a whole different person.
I guess.
But I think it's because she was high on drugs.
When she came in? Oh, wow.
Because when she came before me again, she was a different person altogether.
She
looked
detox
different,
and cleaned her
was
system.
And I said to her, what took you so long to come back? I said, because you've been sitting in jail for 90 days. I said, you never filed a motion to come before me to ask me to reconsider the sentence or to mitigate the sentence, whatever. I said, of course, I'm going to let you out today. Clearly, I mean, she was very, very gracious, and
I'm sure
she apologized and etc.
90 days. That is.
She said half of the sentence before she came back, but I don't know. I believe, but I couldn't tell. I can't tell if a person is high on cocaine. I just can't. Not sitting from the bench. Alcohol, somebody's going to tell me, Judge. Yeah. That person is.
Yeah, there's an odor.
Yeah, that person has an odor. Or that person is high, or something like that. But when it's drugs, sometimes it's very difficult.
Right.
And you don't know. But I believe we subsequently found out that when she lost control in the courtroom, that she was high.
Okay.
On cocaine.
Okay.
And I guess it took a while for her to really assess that, maybe if I apologize to the court, I can get out. But that happens quite a bit. So
is that a shift from a different time?
Oh,
Are you
I
seeing
think
more
it
of that?
It's more of it. It's more of it. There's a lack of now, and I see this. I don't see a lot of this in some other courts, so I'm not saying this happens in all the courts in the state of Ohio, but it's really loose sometime in Hamilton County. And I said to one guy from Dayton, since we're in Dayton, I'll tell the Dayton story. One lawyer came to my courtroom in Dayton, and he said to me, Judge, I am appalled at the way people control themselves in your courtroom. And this would never be acceptable in Dayton. And I said to myself, no one will ever come to my courtroom again and say that. Because the structure and the way we operate is really a busy court. And I may have 60 or 70 cases. There are a lot of attorneys.
Are we talking about
a day?
A day?
Yes, that's minor. That's a little docket. But so we have lawyers in there, we have officers in there, we have sometimes probation officers, you have witnesses, you have defendants. In Hamilton County, we have 2 prosecutors. We have a prosecutor for City of Cincinnati cases, a prosecutor for all the other Hamilton County cases, and then some municipalities have their own prosecutors like Norwood and et cetera. So you can end up having 2 or 3, at least 2, but sometimes 3 or 4 different prosecutors. So it's a
and
busy,
all of this
busy
is
court.
going on.
All of this is going on at the same time. And then people are bringing me papers to sign, and so it's a lot of movement. And but I said to myself, this will never happen again. And because what I would do is that I knew the movement was going on, and I knew how people were moving and talking and doing everything. But I'm concentrating on what the defendant is saying, what the lawyer is saying, what the prosecutor is saying. I'm not concentrating on all the other noise. I'm trying to block that as long as I can hear. But no, I stopped. No. I concentrate on everything in that courtroom because I have 2 bailiffs. I have an administrative bailiff and a security bailiff, and they're pretty good about telling people to quiet down and to not do this. Sometimes lawyers will come in there with their drinks. We tell people you can't bring drinks in. They come in with their drinks. I tell my bailiff to go quietly tell them to put those cups in, the bailiff to go tell the attorneys to put those cups and bottles away. You can't come in here with your coffee mug and et cetera. And then I had one prosecutor who was texting all throughout the court.
Oh no!
And I didn't know what she was doing, but my bailiff told me, you know, she's texting all throughout the courtroom. She said, I'll speak to her. I said, you speak to her first. If she doesn't listen to you, then I will say something about it. That was unheard of. You just didn't do that. But it's just the loss of civility, I think, and it happens quite frequently. And so you have to maintain control. Sometimes it's very difficult when you have a person who's challenging you. And then I'll have people come in the courtroom. Now, there's a sign at my bench that says Judge Cheryl D. Grant. And I'll have people stand before me and say, what should I call you? I said, how about Judge? Or they will say, Miss Grant. Now, they don't do male judges like this.
I definitely don't believe they do.
Or Miss this or Miss that. I say, would you mind using the word judge? I mean, so it's and this is just not, this is all groups of people. I mean, it amazes me that as a female judge, I can be Miss, or I don't know what to call you, and then as a male judge, you have absolutely no question about what to call that male judge.
I just think, again, we're dealing with cultural dysfunctionality. I believe that women have always been treated incidentally, insignificantly, and that the notion that you exercise power, which is why I wanted to get into this, because that is your courtroom. You have the ability to lock people up. That's more powerful than the IRS, actually. There's a process with them, but they come in your court and it's like, bye.
Some people really don't understand that, because I tell them all the time, why would, another thing I had to learn, and I put a note on my door, and I was questioned by some other judges. No muscle shirts.
Oh, God, no.
No shorts.
Right.
I've had women come in there with shorts, I mean, really, really short shorts with their heels on and their halters and their, everything. I said, no, no shorts. You cannot wear shorts in my courtroom. And I put it on the door. Judge, you can't tell people how to dress. I said, in this courtroom, no shorts. Well, what about the children? I said, if I said children can wear shorts, then that means that somebody else is going to claim that they were that age. I'll leave that up to you, my bailiff, and my other bailiff to enforce that. But they have to sit outside. And so in the summertime, they will wear flip-flops. They will wear muscle shirts. The guys come before me, and they're holding up their pants in the front so the pants won't fall down. And I say to the attorneys, do you talk to your clients about appearing before the court? I said, I don't know them from Adam. I'm getting a first impression.
Right.
Are you, Judge, we told them how to dress, and this is the way they come. So I just, and it's not that they don't have anything else to wear. It's just that coming to court is like going to the park.
Well,
it's
see,
like
that's
going to the picnic.
That's where, and our time is, believe it or not, our time has run out.
Oh, okay.
No, because this is exactly what, and I'm very happy that you graced me with coming, because I consider you one of those female pioneers. I always have. And I look at the culture and the conversation, what everyone says, well, the playing field is level. And I'm like, excuse me, are you drinking some funny stuff? Are you smoking some funny stuff? The playing field is not equal. And when you find yourself in a position like in your case where you moved into power and you had the freedom to exercise it in a compassionate way, or in a very hostile way, and you chose compassion in so many ways, and for which our community, our state, our nation has been blessed. And I say that not to fill you up, but because I genuinely believe that you are one of the very few women pioneers in this field, having gone before a lot of other people, and that the respect that is due you, whether they like it or not, they give it. I tell folks, you may not like it, but that's a person that earned it, and therefore you give it to them. But we're going to wrap up, and I hope you all have enjoyed today's segment with my guest, the Honorable Judge Cheryl D. Grant, who retired last month from the bench after 20 years of service in a tough county, Hamilton County, Ohio. Oh yeah, the real deal. And leaves a legacy that's going to be really, really hard for people coming behind her to top. I wish you the best. I hope you learned some things. I hope you listened carefully. And look forward to seeing you the next time around. I'm Michelle Graves on The Power of Money. You take care. Bye-bye.